Welcome back to another video, and today we have a couple that's getting divorced. Originally, they were going to do 50-50 custody, and then something happened, and all of a sudden we're not doing 50-50 custody anymore. There are allegations flying, and let's just take a look at it.
Court will note the appearance of Ms. Reed on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. The matter is before the court on the defendant's motion for temporary custody, parenting time support, exclusive use. I do note that the plaintiff has filed a response, and I've reviewed all of those. Anything else to add, Ms. Thomas?
I do, Your Honor. I was quite surprised from the response. I've never seen a party so blatantly attempt to get hearsay information before the court as has been presented in this matter. I will first ask the court to strike all attachments to plaintiff's answer to defendant's motion as hearsay, which in some cases were specifically prepared for this very motion. Counsel should be frankly ashamed and should be admonished accordingly. That's crazy. I would ask the court, first of all, to note that plaintiff's complaint for divorce at number 10, wherein plaintiff clearly states, and I quote, "It is in the best interest of the minor children for the parties to share joint legal custody and joint physical custody with an equal parenting time schedule." First, we note that there are minor children, not a minor child. And secondly, plaintiff specifically requests joint custody and equal parenting time. In defendant's answer to complaint at number 10, he recites his concerns regarding plaintiff's drinking and his reasons for believing that plaintiff's request is inappropriate, and asks this court to grant relief, which is in the minor child's best interest, not indicating whether it was custody for him or her or whatever, just what's in the children's best and safest interest. Subsequently, based upon happenings, we filed two motions, one regarding financial matters that although 10 days ago, we believe we had an agreement on it, and I believe we still do, we've not seen a signed order yet. The other motion was, in fact, the present motion regarding custody, parenting time, child support, exclusive use on a temporary basis. In our motion, we've identified the defendant, his concerns regarding the care of the minor child based upon plaintiff's use and abuse of alcohol. Of course, unlike plaintiff, we did not attach our eventual exhibits, including photos and copies of posts wherein plaintiff acknowledges her drinking issues to said motion, as it's inappropriate to do so. However, we clearly quoted plaintiff's own words where she has, in fact, acknowledged her drinking issues. The immediate response from plaintiff was to file an amended complaint for divorce, wherein the only change from her initial complaint was paragraph 10 and the correlating request for relief, wherein she now requests sole legal, sole physical for herself and reasonable parenting time for defendant, indicating that it is in the best interest of the minor children for the plaintiff to be awarded sole legal and sole physical custody of the minor children, with defendant having reasonable parenting time. Said amended complaint was clearly filed in retaliation of defendant's present motion and for request for plaintiff to receive help for her alcohol addiction, and wherein he requested temporary custody until there's a positive movement for the plaintiff receiving the help that she needs. Parenting time as in the children's best interest, with restrictions as necessary just to keep them safe. Court monitored alcohol assessment and treatment and a child support based upon the Michigan child support formula. Between her first complaint and her amended complaint, plaintiff offered no facts or change in circumstances in the intervening 50 days since the filing of her complaint for divorce, although defendant received defendant's response to her amended complaint on May 8th and has had defendant's motion since May 6th. She failed to file an answer timely, filed her hearsay evidence attached to her answer on Friday afternoon, not allowing us time to do any kind of a reply. We know that we were trying to work together and work something out, but still, that was still kind of attack by surprise when in fact that's not what had been claimed in the first time around. We believe that plaintiff's outlandish allegations, which appear to be from her anger with defendant for bringing up her alcohol addiction at all, the creation of documents to support her answer questions not only her veracity of the signer, but the ethics of all those acting in conjunction with the plaintiff. Step one of alcohol reliance is admitting there is a problem, and although plaintiff wrote it down, she will not admit in public she has any issues, which is sad, and she's not going to get the help she needs until she's admitted that. Defendant doesn't believe that plaintiff's a bad mom. He believes unless she gets an assessment and treatment for her use of alcohol, she will continue to put the kids at risk, as she has acknowledged in her own words, in her own writing, that she's done in the past. I believe it should be clear to the court that under these circumstances and with recent police involvement, these parties cannot peacefully reside together. And plaintiff has repeatedly stated her intent to move out. In fact, her plan was to move last Friday, but then she got mad at defendant and it had chosen not to leave. Then I I thought she was partially moved, but I'm not, I know that that was the agreement of the parties. And so we're asking that the court award defendant exclusive use of the marital home and require the plaintiff to move forthwith. Without random monitoring, defendant believes that plaintiff will continue to play the system as she has through testing her breast milk prior to nursing to make sure there's no alcohol in it, although she claims she knows after 3 hours there will not be, and so no one would have cause to contact CPS. Through hiding her issues and orchestrating her co-workers not to tell, defendant is prepared to testify as to all the allegations are truthful, and the ones with quotation marks are absolutely actual written words by the plaintiff, meaning she knows she has a problem, simply will not admit she needs help in detriment to her own children. In attempting to work something out with plaintiff to get help, defendant had offered a forensic assessment and evaluation with Dr. Haugen with treatment as he sees fit, and was prepared to have Dr. Haugen even review the defendant's suggested use of SoberLink as the first step to a solution. Defendant was also willing to defer plaintiff paying him child support until the beginning of next year for the sole purpose of helping with the costs related to SoberLink. With random testing and whatever criteria this court may believe is in the best interest of the children regarding any missed tests and or positive results should define the parenting plan on a temporary basis. And of course, defendant defers to the court and your expertise with regard to that. Mr. Martin simply wants his children to be safe. And until there's help, until there's an assessment, until there's, we're asking a forensic assessment because that's the only way that the entire story is going to get to Dr. Haugen. One quick mention that we will say, for example, with the attachments and all this is that the photo that plaintiff decries is from the same day as the day she filed for divorce is incredulous to me, as she filed for divorce on March 18th, 2024. And that particular photo was posted on Facebook on February 4th, 2024. So more than a month beforehand. So unless there's magic clairvoyance or something, it's just a continuing ongoing lack of veracity. We're asking that this court keep these children safe, grant Mr. Martin the exclusive use of the home, him on a temporary basis have custody, and then have Dr. Haugen involved. We're more than happy to share with Dr. Haugen what we believe this SoberLink, the two-step plan should be. And if he thinks that's excessive, that's fine. But we want to make sure the kids are safe when they're in mom's care. We think she's a good mom when she's not drinking, but that's not what's been happening, and we have to make sure they're safe. So we're asking the court order accordingly.
Okay, Ms. Reed.
Your Honor, my client denies all allegations of alcohol abuse or substance abuse. She is currently seeing a counselor to deal with defendant's emotional, physical, and mental abuse that he has escalated since he's been served with the complaint for divorce. We did amend that complaint as he escalated his abuse since he was served to solely legal and so physical, as it's abundantly clear that the parties can't co-parent and can't communicate well, as evidenced by the defendant's example in his motion of my client simply creating a bubble machine for Roman to play with. He manipulated it and turned it into some sort of incident of child abuse and neglect, that my client was putting this child at severe risk of harm. They were putting together a bubble machine to play with. This is ridiculous. My client would agree to doing a substance abuse evaluation with Dr. Haugen to disprove the defendant's outrageous claims that she's drunk all the time. Her employer has never reported she has a spectacular work history. Her coworkers will testify that they have never seen her drunk at work or drinking at work. The doctor for the children will testify that my client is providing and scheduling the child's care with the doctor's offices, provides soothing and comfort for the children when they're upset at the doctor's office, and she's a fantastic mom. We find it very interesting that he claims that my client's providing an unstable environment or a dangerous environment and is at risk of putting these children in danger when she's been the parent that provides care, comfort, clothing, feeding the children, doing everything for these children. She's the parent that gets up at night and soothes London and feeds London while the defendant is sleeping, and he sleeps through her cries. She's breastfed Roman until he was the appropriate age to stop. She's continuing to breastfeed London, and the defendant doesn't have any problems with her breastfeeding these children, yet he's claiming that she's drunk 24/7, which does not make sense. He's also claiming that she's unstable and unsafe, yet over the weekend when she moved out last week, she had the children in her custody. So we're denying all of those allegations and asking
Reed, I don't need anything more. What I'm going to do is, in this case, obviously, we are diametrically opposed to testimony, if you would, of offering that, or positions in this case. So the court's going to need at least some evidentiary hearing in this matter. What the court is going to do is, I'm going to schedule this for a limited scope evidentiary hearing on June 5th. So Wednesday, June 5th at 2:00 p.m. I'm going to allow each of the parties to have 1 hour to present their case through obviously their own testimony or others, but they'll have 1 hour each, and that's taking into consideration direct and cross-examination, and the court will reserve and make a decision at that time on the motion in this case. So we will see you all back on June 5th, and we'll get it all taken care of at that time.
Judge, can I ask a couple questions? So at that hearing, can we bring witnesses should we so desire?
You have 1 hour. So
Okay, to
if
use
you-
any way I want to.
If you bring witnesses and don't have your
Okay.
client, you're taking up your hour that way. That's.
Nope, that's fine. Okay.
Okay.
And
So
then,
each party will have 1 hour, and that's including, I'll keep track of cross-examination and examination. So
okay,
obviously use your hour the way you want.
nope, that's fine. And
Okay.
then it sounds like that, I guess a couple other things, and I didn't mention that Ms. Reed did not either. I believe both of us agree to communication should be through our family wizard. If that's the case, I would like to get that started before then even.
Ms. Reed,
If Ms.
is that agreeable?
Yes.
That's fine. Why don't you put
And-
that in the order? Ms. Thomas, you also, plaintiff has stated she'll do an assessment with Haugen, so you can put that in as well.
Is this court fine with it being a forensic assessment?
Ms. Reed,
I don't have an issue with that, but we're also requesting that the defendant undergo one as well.
Ms. Thomas, you have any problem with being mutual?
I do not.
Okay,
No.
go ahead, put that in the order.
Okay, and then, it sounded like Ms. Reed said that, Ms. Martin had moved out. Is that, I just want to make sure what that situation is too.
Friday. She moved out Friday.
Okay,
So at this point, exclusive use to Mr.
you can give him exclusive use because she obviously claims she's out of the house.
Okay, all right, great, thank you.
Okay, we'll see you back on June 5th. Have a
Great,
good day.
thank you.